you cannot do several things to those properties while the case plays out. You cannot encumber the property. Usually the FBI or the DEA, more commonly the DEA, will try to seize money. Hey everyone, David Tarras here, head of the federal and white-collar practice at the Rossen Law Firm. What we're going to be talking about today is this process known as forfeiture. And if you have a situation where you're facing a potential forfeiture, which is very common in a federal or white-collar case, the importance of discussing forfeiture early on in your representation, of our importance of discussing this with our clients early on, cannot be overstated. A lot of times forfeiture is not discussed early enough in a case for various reasons. Some attorneys believe that it might sound pessimistic because forfeiture does usually accompany in the federal system either a criminal charge or possibly even more so later a conviction, whether it's by a plea or a trial. But forfeiture has to be a discussion that starts early because while we're going to explore every single avenue to get you a phenomenal result in your federal or white-collar case, we still have to always be prepared for the future. Because while freedom is the ultimate protecting freedom, the ultimate goal in any case, any federal case, in any case, period, we can't overlook the fact that sometimes the government will seek the seizure of your assets, which can be a home, which can be a car. And because so many of our clients have family and children, and even if you don't, but you have assets that can, being the seizure of those assets can affect other people, it's really an important conversation to have early on in the case. It's in no way indicative of the fact that we don't intend to get a result that results in no forfeiture, but you need to be prepared for the worst possible outcomes while we fight your case and defend your rights and your liberties. So this process of forfeiture is something that the federal government and the United States Department of Justice has ramped up. It's been around forever, but a lot of times, maybe a decade or so ago, even 5 years or so ago, it wasn't uncommon for lawyers to be relaying to their client, don't worry so much about the forfeiture. They're probably never really going to come and take your property when this is all said and done. If you are convicted, if we're talking about a criminal forfeiture, which is a kind of forfeiture that is very often part of a federal charging document, such as an indictment, very often in the indictment itself, it will include a forfeiture allegation putting the defendant, putting defense counsel, our team, on notice that they do intend to seek forfeiture. So very commonly, it's been neglected from an early stage. And even now, I still hear what sometimes turns out to be horror stories of attorneys who have neglected the importance of preparing for the possibility of forfeiture at the early stages of the case. And why is that important? When the government has identified an asset or a property of yours that they believe is somehow tied to funds that were earned in a criminal manner or the proceeds of illicit activity, they intend to file either in the criminal, if there is a criminal indictment or a criminal information, an allegation of forfeiture. Sometimes they also bring a civil forfeiture, which is a separate civil suit where they intend, and this is before criminal charges have even been filed or sometimes while criminal charges have been filed, which is essentially a notice that they've done investigation and they intend to continue that investigation and ultimately attempt to seek to take your properties that they believe were unlawfully earned or paid for, assets or properties. You also have a scenario called administrative forfeiture, which is where usually the FBI or the DEA, more commonly the DEA, will try to seize money most commonly cash, that they seized as part of an investigation or an arrest or some sort of interaction that perhaps did not lead to criminal charges, but they still believe that they had enough cause to try and take away from you. We see that often individuals that may be alleged to be couriers for alleged drug traffickers, and they're stopped by the feds with cash in their car, and the feds will take that cash, and then often you get a letter in the mail saying the FBI or DEA has started this process and you have certain rights to challenge this. Now, the problem with challenging an administrative forfeiture at that part is because, unsurprisingly, they're the federal government, so they're always looking for some trick, is to try and get you to say, well, you can challenge this, but you have to make certain admissions and give us a notarized and legally sworn reason why we should not give this. And then all of a sudden you're making admissions you don't want to. So it's very important to have an attorney if you ever get such a notice, or if you've ever been stopped and had any of your cash or property seized. But really what we're going to be focusing on mostly here is a criminal forfeiture. So commonly, as we've discussed, the Department of Justice or the U.S. Attorney's Office or the Assistant United States Attorney in the indictment, in the charging document against you, will include a forfeiture allegation. And that is usually the first time that the government will put you on notice that they do, at the end of the case, intend to seek property and assets from you. Sometimes those assets or those properties are listed in the indictment. Not always. It depends on how long the investigation has gone on for, or equally depends on whether or not they have already had the forfeiture unit, which commonly involves the marshals and the FBI, already identify assets. It's more commonly a blanket notice, but if there's a forfeiture allegation, which we see most commonly in white-collar or financial crimes, also very commonly in drug-related cases or drug trafficking cases, sometimes in cases involving exploitation of children or computer pornography. In those, they're almost always going to include a forfeiture allegation that they intend to take the devices that they may have seized, assuming they found any material of this nature on the devices. But really, in the white collar and the financial complex cases that our firm handles, and the drug trafficking cases, we see this almost automatically. If they have not included any specifics regarding what properties or assets, vehicles that they intend to attempt to forfeit when the case concludes in the indictment or in the information, depending on whether they've gone to a grand jury or if our client with our counsel has waived grand jury, then they commonly file something very soon after called a bill of particulars. They don't have to do this, but if they have already, through their investigation, identified assets, properties, vehicles that they believe even early in the process were proceeds or were gained or paid for with proceeds from illicit activity in the eyes of the government, of course, then they may file a bill of particulars. And what that bill of particulars says is a list of properties, and that you cannot do several things to those properties while the case plays out. You cannot encumber the property, which means put any sort of additional liens on the property. You cannot take a mortgage on the property. You have to actually maintain the property. You have to continue paying your HOA dues. All of these things we have seen, especially in the Southern District of Florida, where our firm is based, but also around the country. They're extremely, extremely aggressive, more so now than ever, about making sure that a bill of particulars, that these properties are identified early on in a federal criminal case. So once you have that, once that's already in place, it is really important, coming back to the purpose of this video, that you have a conversation, that your attorney has a conversation with you about these properties. When was the property purchased? When was the car purchased? What funds were used to pay for the property? many other questions that can help us determine early on that regardless of the outcome of the criminal case, do we have a very justifiable basis or not to challenge the forfeiture? And if we don't, which sometimes can be the case depending on the circumstances, perhaps the most important reason to address it early on, as so many attorneys fail to do because it takes a lot of time and work completely separate from actually defending your freedom and fighting the charges, is because if you have a family member who resides on the property with you, if you have other people in your home, if this is a vehicle that belongs to a child or a wife or a parent that they've listed in this bill of particulars, or that the government has made you aware, made your defense team aware that they intend to forfeit, well, we have to plan accordingly, okay? And again, this is not to take a pessimistic point of view, but the DOJ, the government is going to be the government, and we have to protect not only you in the case, but your family as well, okay? So we always want to have these conversations early. We want to gather as much information, which sometimes includes deeds to the property, records that we can gather from the local clerk of courts in the district where you've been charged, or more likely where the district is located and the property is located, if it's different than where you've been charged, so that we can start preparing to challenge the forfeiture and challenge the seizure of this property should the government decide to do so when the case concludes. There's many different ways to go about doing this. Some of these we've already discussed here and are going to discuss in future videos as well regarding forfeiture, but it's just really, really important to plan early. One of the biggest tools that we have, and not a lot of lawyers know this, but something that we've been very successful with, is we will have our client start, and of course, depending on how early we're retained, this can change and how much we're able to accomplish this, but regardless, have our client start putting aside as much funds as possible for the potential likelihood of a forfeiture. And that's not always possible. Okay. Sometimes the government has frozen your accounts and you didn't start this process early enough. But if possible, if there's any way, we're always going to try and have our clients start putting aside basically what we can call a forfeiture slush fund. And why is that? If there are properties that they're seeking, very commonly, we are able, and we will certainly do everything in our power, to negotiate with the federal prosecutor who is prosecuting your case. And very oftenly, you'll have a federal prosecutor, an assistant United States attorney, or a DOJ trial attorney, and they will also assign a separate federal prosecutor from the forfeiture division to your case as well. And so we want to start preparing early to negotiate if the outcome, God forbid, results in a conviction, or if the best thing for our client is to enter into a plea, to start negotiating what's known as a money judgment, okay? A money judgment. A money judgment in a forfeiture action is extremely important because it gives you the opportunity to pay with cash, with funds, for the value of the property or the value of the assets that the government is seeking to avoid the potential seizure and the really, really devastating consequences that can come with the seizure of a home or a car, and most commonly properties, okay? Because if the money is there, if the cash is there, we want to propose having that put towards the property so that yourself or your children, if our client is, God forbid, sentenced to a term of imprisonment, we want to also make sure that the family is protected, that your family's not going to be kicked out, that your husband's not going to be kicked out of the home, or your wife and their children if the government comes to seize it. So we always want to explore every opportunity to do a money judgment in lieu of forfeiture of property or assets. Another thing that we can do early on is to start to identify something known as substitute property or substitute assets. Substitute properties or substitute assets are properties or assets that the government, through their investigation, has not found have a direct link to any criminally acquired funds or proceeds from illegal activity. But if the property that is subject to the forfeiture is, for whatever reason, no longer available, or if it had been sold prior to the case, or for whatever reason, it's not an option anymore to be seized and forfeited by the government, substitute properties can be valuable, but it can also be very difficult and very dangerous and very harmful to our clients and their families, because then we're in a scenario where the government is saying, well, the house or the car that unlawful money was allegedly used for is not available, so we're going to take the home or the car, the apartment, the condo that had no ties to any unlawful activity. And that's a very, very, very difficult thing. We get calls, and it's not always too late, but sometimes we get calls that are too late where they say, the government is coming to take my second home, my ex-husband or ex-wife's home that they're saying is a substitute property in these scenarios. How is that fair? It's not, but the government is going to try and do it to make up for the actual forfeitable property that is no longer available. The money judgment aspect comes into play there very successfully. So we want to start that process early as well. God forbid the worst scenarios happen, but also we want to, if we are negotiating or at the point that we may be negotiating with the forfeiture section of the United States Attorney's Office or the Department of Justice, that we are limiting as much as possible what properties can be considered substitute properties or substitute assets, because those are usually the properties or assets that can cause, if seized by the government, some of the most hardship to the families. Okay, so we have to always early on identify substitute property. Sometimes there may be a substitute property that we want to propose as a satisfaction of the forfeiture so they don't seize something else. Another tool that we have, if we start the process early enough and are prepared to negotiate these potential consequences of forfeiture with the government, is to propose to the government that maybe if they're not willing to accept a money judgment, or if our client is simply not able to raise those funds because of their pretrial conditions that says no new loans, no new cumbering of the property, it's all it's very silly what the government does, because they say they want this money, they want to be paid back, but in most white collar cases, they also say, well, you can't take out any new lines of credit, you can't take out any encumbrances on the property in order to pay this back. But we always can, and at least attempt to, in these cases, to try and negotiate with the government to say that, look, if you have to sell this property, allow us, before you go and issue your final order of forfeiture, your final seizure of the home, give us a certain amount of time, either following a plea most commonly or following a sentencing, to have the home sold by our own means, because the government is going to put the home up for auction. They're going to take usually the first deal they can get. But we have been successful here at the Rossen Law Firm. I've been successful in saying, look, we actually have a broker, and we have to be transparent about it, but we have a broker or a dealer that is willing to limit their fees and believes, based on the market, based on their abilities, that they can get this home or this property, this building, this asset sold for a substantial amount of money. And the government, if you come to them the right way, and if you know the rules regarding it, like we do here at the Rossen Law Firm, we can negotiate sometimes for a private sale of these properties. And what will happen there is that if we can sell the property with a realtor and work down their fees as much as possible, any leftovers that from the sale, if let's say the forfeiture number is $500,000 and we're able to sell the home for $800,000, our client, you would get to keep the remainder. The government can only take as much as the forfeiture amount that they are listing. Okay. And so we also early on want to make them commit to that number so they can't just go taking everything. These are just some of the reasons why it's important to hire an attorney like myself and the attorneys at the Rossen Law Firm that understand forfeiture and know the different avenues in order to protect yourself. God forbid the government does come for your properties, and protect your family in these properties as well, and these assets as well. So if you have any situation, of course, you're facing a prosecution or you get a letter of a forfeiture notice, whether it be in civil federal court or you get one of these letters from a federal investigative agency like the FBI or DEA, please do not hesitate to contact the Rossen Law Firm as early as possible so we can start protecting your future and your family's future as well. Thanks.